All right, everyone. Thank you for coming along. It's lovely to meet you all briefly. We'll do some longer introductions in a minute, but I'll get through some of the more boring stuff, setting the scene for this workshop first. So Jason Scarborough from JS Regulatory Services was planned to deliver this workshop, but unfortunately he has not been able to make it up to COFS. So I've been working with him over the last couple of days to put together another version of it. I'll be presenting it and have co-developed this presentation. I have experience with litter and illegal dumping regulation particularly. So my role is as a senior resource recovery consultant at RMCG. We focus on agricultural regional businesses. And so my role has recently shifted into working with large agricultural businesses on their waste permits and other permissions, as well as how they can, I guess, prevent illegal waste on their land. It can be a big problem for some of our farmers. On top of that, I also run an association for officers who investigate and enforce against litter and illegal dumping. So that's a bit about me. We will acknowledge the traditional custodians of the country that we work on. I'm not quite sure of which country we're on here, unfortunately. We pay our respects to the elders past and present, and we acknowledge any emerging leaders who might be here with us. So the purpose of today, we are going to learn the considerations that you should have when you're appointing authorised officers. Get a grasp of the legal frameworks for gathering evidence. We'll throw in some techniques for investigating an incident of illegal dumping. Also, when and how you might seek to collaborate with another authority or another organisation. And how, most importantly, you're going to leave here knowing how to make a defensible decision when you're investigating and documenting your processes. So today, I want you to really focus on the principles that we're putting forward. There's people in this room from all different states, in all different roles, and who will be using different types of legislation. So we're going to show some of the examples. You've got a handy reference sheet. This one, the stapled one. So this has some of the key excerpts of legislation that officers would regularly use when investigating illegal dumping for New South Wales, ACT, Victoria and Queensland. Everything we talk about here is going to be generalised, but when we're into the activities, I want you to try and use your specific legislation and focus on the transferable skills. So again, focus on the principles of what we're talking about. So what are some of the prerequisites for enforcement? You know, you're a council, you're an authority who is wanting to go out and investigate and enforce a potential incident. Before you go ahead, you need to make sure that you're not missing any of these. Do you have the time and resources allocated? Have you got supervisor and organizational support? In particular, do you have the investigation skills? Has your organization equipped you with those? Do you have the proper authorizations and delegations? Noting that some states have acts that provide authority via the act, and some have legislation that requires delegation for specific permissions. It's a key differentiation that you must be aware of. Do you have a policy? So when you're out in the field and you need to make a decision, we don't want it to be subjective. We want it to be consistent. So you need to have an organizational policy. Do you have an evidence management system? Sounds fancy, doesn't have to be, just needs to be, again, consistent. And do you have trust in your professional judgment? Do you have trust in your skills as an investigator? So, before we go any deeper into the actual content, now that we know the prerequisites, I want a bit of a let's get to know the room. Can I get a hands up on a state basis? Who's here from New South Wales? Oh my God, almost all of you. Who's here from Victoria? Represent. Yeah. ACT? Queensland? The Lone Ranger. Moreton Bay, it's a lovely area. Anywhere else? That must be everyone. So mostly New South Wales. Great, okay. Who here is authorised to investigate an incident of illegal dumping? 2 people. Okay. Are you sure? Yep, all right. Now, who here has ever wanted to investigate or thought about venturing down that pathway? Okay. All right, well, I'm going to add an extra question to the next bit then. So, I'm going to give you a couple of minutes at your table, get to know each other. In particular, I think one of the important things, have a talk about this checklist, put yourself in the role of an investigator. Would you be ready to go out and do an investigation? But also maybe have a chat about why you're at this workshop. No one wants to investigate. Why are we here? And once we can get that out, we might make some changes to the rest of the content as we go forward. Okay, so a couple of minutes, off you go. Okay. Hopefully you've gotten to know some of the people on your table. I'm gonna do that cliche mean thing now where I pick some people to have a chat about why they're here. Can I go here? Can you let everyone know why you've come to this workshop?
Yes, so in our council, I do waste education, so I'm not in the compliance team, but our compliance team have just set up an illegal dumping working group, and I'm part of that. And we're trying to work on how we can reduce the amount of illegal dumping through education as well. So I'm mostly here more to understand how we can prevent it and just take any knowledge and bring it back to that working group.
Okay, thank you. That was Charlotte Weaver, by the way. I'll come over to this table. Does someone here want to give us an idea of why they've come along to the workshop? Go on, Elliot.
My name's Elliot from Bayside Council. I think you know why I'm here, Sam. Recent experience assisting us with our litter and illegal dumping strategy. So I'm here from a strategy waste education team as well, similar to Charlotte. Really just looking for more insight into how the investigations take place and how those kinds of decisions are made on the ground, and how from an education team we can support the compliance team.
So I read from that he's here because I helped him with the strategy and then it got worse. So, okay, so anyone from this table? All from Bayside.
Andrew from Parramatta. So illegal dumping sits under my portfolio. So, the remit is got teams that look after education, enforcement and removal. So really here just to listen to everyone else, see what they're doing in their councils and seeing whether there's any of that learning I can take back to my council.
All right. Over here. Who wants to put their hand up?
They all just look at me for everything. I'm Lisa. I'm from Canterbury Bankstown Council. Look, the majority of us are here, but just like everybody else is as well, you know, to learn, to upskill. I think most people have a big want to understand prevention and where that sits in sort of mitigating and stopping illegal dumping. But we also, from my council perspective, we do both. We do the education, but I will hunt anybody down if I have to. So we've got delegations to do it, but education is our priority with enforcement as a second tier.
We'll go on. What's the state of play, Lisa?
Yeah, we're a big LGA. We're the second largest in New South Wales, sitting at about 385,000 residents. Mostly residential dumping. We have a little bit of parkland dumping, but most of it's residential dumping. Look, we've made a big impact in some of our real hotspot areas by looking at doing some real sort of in-depth enforcement. That's come from a lot of data that we've done before my time. So before Lisa, there was a lot of data sort of collected. Since I've come in working, and we've got a lot of projects that we're doing to do reduction, and some of them are sitting as high as sort of like 65% reduction in illegal dumping, but then enforcement just follows on the end of that. So we try to do prevention. I think everybody does. That's what everybody wants to do. But we've also got a very brave council in terms of, like, if we have to do enforcement, they will let us. They say go for it. You know, they're not going to hold us back and say, oh no, you know, it sits very high on our councillors when they look at all of the issues in Canterbury Bankstown regional area. Illegal dumping sits in their top 3 priorities, and the same with our community. When we do our surveys, it sits in our top 3. So we've got a lot of want from the community to get in there and do stuff around legal dumping. I'm just one person at the moment, but we're actually about to put some more staff on because the programs that we've been running have been quite successful, and we've seen some big drops in reduction. Well, I've done a lot of work with Jason before. He's a great guy to work with if you need resources as well. I was just going to give him a plug. But yeah, so are you guys finding mostly residential stuff? How many cleanups do you guys have a year? About 52? It looks like it, yeah. No, we're just trying to follow you guys. Like, you know, I thought you guys had 52. No, we have 4 a year for our muds, 2 for our residential guys. A lot of our stuff is like unbooked bulky waste, so we'd have to do a lot of work around trying to get people to book it in.
Thank you very much, Lisa. I'll just point back to this list. You know, Lisa sort of commented on quite a few of the things on that list there. The one thing that I didn't hear you comment on was organisational policy. Sure, over to Danielle.
Charlotte, just like Charlotte had said, we a couple of years ago had the Clean City Strategic Plan. So we have 4 pillars, and we also have an illegal dumping working group. So we have teams from across the organisation, our reg services team, plus us in resource recovery and sustainable future, customer service, comms, and waste and cleansing, all working together to see that we have sensible processes, we're being as effective as we can, and we're learning from each other the whole time. So that has been fantastic. It's got support from the top because it's councillor key issues, and support across the organisation. It's written in our operational plans, but also in the Clean City Strategic Plan.
That's great to hear. So the sense I'm getting is there's a few people in this room who have councils with working groups or starting to collaborate more, starting to formalise more, and so trying to understand how you could potentially improve that collaboration across different departments. One last table here. Would someone like to let us know why they've come along? You're the only one from Queensland.
I'm going to regret that. My name's Kath. I'm from Moreton Bay, and the only one in Queensland, as we know. We're one of the largest, third largest council in Australia, nearly 500,000 residents. I'm a councillor, but I just wanted to understand a little bit more what everyone else is doing and what I can do to support our staff cleaning up. We have a lot of illegal dumping, things like tyres and mattresses and things like that. We don't have a bulky waste collection service or anything like that. So just things that we can do to support the staff.
I'm a Queenslander at heart. From memory, you have tip vouchers. No? How do people access the waste disposal options?
We have free tipping up to 26 visits per year or 3 tonne, whatever gets first. So it's just collected on a residential basis.
And so you're trying to understand what people are doing. Do you have a policy and systems in place for your staff? Yep, they do. Great. Okay. Based on time, we'll keep going, but did anyone else really want to let everyone know why they're here? No? Okay. Okay, so we have 2 authorised officers in the room, but one of the key things that you need to consider when establishing an enforcement or investigation program is the appointment of your officers. So there are some legal requirements. Appointment requires a written instrument. It must specify the legislation and the powers that officer would be using, have clear geographical and functional limits, and be signed by an appropriate delegate within your organisation. So again, I'll remind you, this is generalised across all the acts in Australia that have relevant legislation. The little icons on the top of this slideshow will tell you if there's a magnifying glass, it means you need to go and have a look at your specific legislation and understand how these key principles apply to you. And if you see the little institution, that means really you should have templates. You should have a system, a policy, or a template so that all of this activity is being done in a standardized way. The key considerations for an officer are that they must accept the appointment. They must have training requirements that are met and documented. They'll be issued an ID card, which they're required to have when they're conducting investigations. You, as an organisation, must maintain a register of appointments, and a regular review of those appointments should be done. Most councils already have that system set up because of the suite of legislation that's used by councils. Key takeaway is if you don't have a valid appointment, you do not have a valid investigation. So that's the first thing to think about. So we'll move into stage 1. We're going to use a case study, and you'll have this beautiful evidence matrix. You're going to put yourself in the shoes of an authorised officer, and over the next few slides, we'll be conducting an investigation. So stage 1, you're an authorised officer, you've received an initial report and you need to triage it. Hopefully your organisation has a policy and procedure for this and it's integrated into your customer management system or CRM, whatever you want to call it. But this is the first stage of the investigation process. You'll receive the initial complaints. Someone needs to conduct a preliminary assessment and determine the severity and urgency, particularly looking for hazards of or risk of harm to humans or the environment. You need to allocate appropriate resources. Again, you might need more resources or a faster response depending on the risk of harm. And begin the documentation process. Particularly who's made the report is an important one. So this is the incident report you've received. Oh, that's not the right button. This is the incident report you've received. A big pile of household rubbish. Contains carpet and carpet underlay, plastic tubs with carpet glue, a broken lounge, mixed domestic waste, and timber. It's a horrific sight. So one of the first questions, like we've just touched on, this has come across your desk. You need to ask yourself, do I have the legal authority to investigate this? So understanding your appointment, check your appointment. Does it cover the location? Does it include the offences that you think might have occurred based on the information you have at the moment? And are you within your jurisdiction? Before you proceed any further, have an understanding of your powers. Can you enter public places or enter private places? Sorry, that should be. Can you gather evidence, take photograph, issue notices, or interview witnesses? Again, in some states, the legislation mechanisms are slightly different. So ultimately, you need to understand your limitations. So what are your delegations? What are your powers of entry? And also Privacy Act obligations. So we go on to stage 2. As we go through, you'll see all of the beautiful examples of illegal dumping I've seen. This one I took myself. We move on to the actual planning of your investigation. So you've got your incident report. You have decided that you are an appropriate officer to go out and investigate this incident. We want to develop a strategy for the investigation, and that really revolves around identifying the offence elements and then having a strategy for collecting information and subsequently evidence for those elements. Can I get a hands up from the room? Do people understand what I mean when I say elements of an offence? 1. Okay. Well, that's good because we're about to go through it, so that's amazing. Okay, so you want to develop your plan so that you can prove that an offence occurred. We're pretty sure an offence occurred by the photo. So to successfully prove an offence, there are some key things. The onus of proof is on us as an authority and an officer. We must be able to relate the action to a specific offence or offences. We must be able to meet the relevant standard of proof. In criminal cases, which most illegal dumping cases can be, that relevant standard of proof is beyond reasonable doubt. We'll go through this a bit more. We must be able to prove each element of the offence to the standard of beyond reasonable doubt. And we must be able to prove any defences that may be associated with the offence. So we prove that the defences are not appropriate defences. Okay. For all of these bits and bobs, we're going to fly through them. The technical, you can come back to them as homework. If there's any burning questions, yell out and I'll come to you, but we're going to fly through this bit. So onus of proof means that you must prove the offence. The defendant doesn't need to prove innocence, and each element must be proven. From a practical standpoint, you need to have a strong evidence chain and eliminate reasonable alternatives, document everything, and have credible witnesses. We've all watched CSI, right? This is the basis of it, or Suits, whatever, you know. Okay, so the relevant standard of proof. People have probably seen civil proceedings a fair bit. So the standard there is a balance of probabilities. That means that an officer has reasonable belief that it's more than 50% likely something has happened. A lot of notices can be issued on balance of proof or request for information. But we're going to focus on criminal proceedings, so beyond reasonable doubt. In that circumstance, you need to be sure that the person has committed the offence. And a good practical test is, are you so satisfied that you're sure and you would stand in front of a judge and make the argument? This one can be funny, and offenders or suspected offenders can really play games with you here. I've seen a lot of authorised officers get caught up in their head when trying to understand what is reasonable doubt. So I've unpacked it here a bit and given you some examples. So it's a doubt based on reason and common sense. It arises from evidence or a lack of evidence. And it's the kind of doubt that would make a reasonable person hesitate about someone having committed the offence. Examples include that a witness only saw a white ute do the dumping, but we have evidence that 3 white utes travelled through the area in that time. CCTV is too blurry, so we know it's a white ute, but not quite which white ute. Multiple people had access to the vehicle, and conflicting witness statements about time. What is not reasonable doubt? So when an officer is getting caught up in reasonable doubt, particularly in discussions with an offender, it's usually based on them not having confidence in their skills as an investigator. Because most of the time you see the arguments that do not present reasonable doubt are fanciful, far-fetched. They're speculation or theoretical scenarios. Maybe someone stole his ute for 2 hours. It could have been his evil twin. Perhaps the witness is lying, and someone might have planted evidence. I personally have used the could have been my evil twin when I got in trouble for stealing chocolate from the fridge. So, we've all been there. Any questions on reasonable doubt? Nope. Okay, defences. So for each offence, your legislation will likely note the defences that are reasonable, and you need to take note of those as an officer. And as you proceed through your investigation, collect information and ultimately evidence to discredit that defence. Let me catch up to my notes. Okay, so as I said, your legislation will have specific defences, but there are also some general defences that you should be aware of as an officer. Those are acting under duress, mental impairment, and accident. When you go through your legislation, you'll probably note that a lot of the defences in there are aligned with those general concepts. And then there are some statutory defences, so lawful excuse, ownership of land, express consent, emergency situations, and a reasonable mistake of fact. Hopefully he's not going off to dump something somewhere. That doesn't mean much. That doesn't mean much. Okay, so the point is, your act will tell you what you should be looking at, but there are some general concepts you should be aware of. Questions on defences? Lisa? Yeah, sure.
The one major thing I do when I'm doing any investigation is pulling up the act and pulling up each of the offences when you are actually trying to prove it, because it's always got the defences underneath it and you can use them and you can look at them. So know your act, know where to find these. I know Sam's provided us with these, but sitting underneath all of these is the information that you need. You don't have to know it inside out, you just need to know where to find it so that you can go and refer back to it when you are doing an investigation. You might have to look at it 150 times in your lifetime, but it's there and use it.
You'll have to look at it thousands of times, not 150 times, but yes. And that's a really good point, Lisa. So the excerpts in the documents you have, they're not complete. They are excerpts. So section 143 of the New South Wales legislation there has a large body of text underneath it that includes those defences. Likewise, in the Victorian Act, it specifically carves out some defences. Again, they align with those concepts, so just be aware of them. Okay, so you're pretty sure of what the offence is by the photo, but we need to identify a specific offence. It's not helpful to go out and say, oh, I'm going to investigate some illegal dumping as an officer. What you need to be thinking, I'm going to investigate a breach of section XXX of the relevant legislation that you're working under. So based on our scenario, I want you to spend 2 minutes on your table, think about legislation you would be using and identify the offence, the actual offence that we are investigating. Your incident information is back up on the screen here for you to have a look at. Okay. If you haven't quite figured it out, do not worry. We're about to go through much more detail here, so you'll get the opportunity to have a look at the guy next to you and copy his work. Okay, so just very quickly, New South Wales. What offence did we identify? I'll go over to Lisa.
Yeah, I was just saying, look, if this was me, I'd actually be starting at using Section 143. Because I think when I'd be looking at that, it's probably around, if that photo came across my desk, I'd be thinking that's nearly sort of like over a tonne or close to it. Sits under 143. There are some tonnage exceptions under 143, so you can either use it to be over or under a tonne, which are new offences that have come in this year, if you all know what they are. And then you'd be looking at proving the elements of person transports waste, and then also proving that it's a place that cannot be used as a waste facility. So I'd be looking up those council records to make sure that Gilchrist... Yep.
Okay. Did anyone identify a different offence for New South Wales? 144 AE? At this point, I would consider that an appropriate one to consider as well. But you, Lisa, would be able to attest this. Sometimes you're going out to that investigation with multiple offences in mind, right? Key point is to be aware of them and elementize them before you go out. All right, so speaking of elementizing, what is an element of an offence? Oh my God, too many buttons. Okay, so commonly you're going to have time, date, place, specifically found in the offence provision of legislation, and you're looking at nouns, verbs, and adverbs. They can be prepared as phrases or sentences. For example, a place that cannot lawfully be used as a waste facility for that waste. I don't know about you, but these all make my head explode. So understanding how you can use nouns, verbs, adjectives, adverbs to sort of break these down, unpack them and understand them is a really important step to make sure that you're looking at every element of the offence. So we're going to look at an offence that's not related to dumping so that we don't get lost in the weeds. This is from Section 7A of the Summary Offences Act 1953 in South Australia. Is anyone here from South Australia? No. No representation. Obstructing and disturbing religious services. A person who intentionally obstructs or disturbs a religious service or a wedding or funeral, whether secular or religious, is guilty of an offence. I do know people. Yeah, it can be useful if you have a library. So for the people online, the question was: is anyone using AI? I guess to look up and extract parts of legislation. It can be useful, but only as an experienced officer. So if you are well versed in the Act and you know how to use AI and you're looking at you want section 115 of the Environment Protection Act in Victoria, I know what that says, but I can't write it down from memory. You can ask it for the excerpt and you can verify that with your knowledge. If you can't verify it with your knowledge independently, then it's not something I would recommend. Yeah. Okay. So this is going to test my English skills. Okay, so we've broken this down a little bit more. The nouns here are a person, religious service. I'm looking at Danielle here for help. A wedding, funeral, secular, religious. Okay, the verbs, obstruct and disturb. And the adverb is intentionally. So that's referring to the person's intent, right? And then the other key thing to consider when elementizing an offence is the ors and ands. I've seen many officers get tripped up on ors and ands. Be very aware of whether your offence requires all subsections to be true, or whether a part of the subsection to be true. So, just very quickly, Lisa, would you like to make any comments on this from the perspective of an authorised officer? No, that's okay. Then we'll go through, we'll keep going. So the next part is a couple of minutes with the offence that you just identified. Go ahead and elementize it. Scribble on your sheet, figure out what the nouns are, what are the verbs, what are the adverbs. If you have a different system, please go ahead and use it. The point is figure out every part of the offence that you need to actually demonstrate in order to prove that the offence has occurred. Okay, everyone, let's keep going. So now that you really understand the offence, all right, let's go. So now that you understand your offence, you understand the elements of your offence, the way that you use the evidence matrix. So as an officer who's going out, you fill in the specific element that you're looking to prove. That's filled in on the boxes across the top right. And you might already have an idea of how you prove that element. And so that specific activity or piece of information could be entered into these rows here. Although what will happen a lot of the time is that will be filled out as you conduct a site inspection, as you conduct interviews, etc. So the purpose of the matrix is to record information and directly link it back to, I'm trying to keep it there, directly link it back to the element you're proving, okay? Now, this may seem a little bit cumbersome, but I have had feedback, particularly from prosecutions officers, that they absolutely love this matrix because it makes their job very, very, very easy to put forward a brief of evidence if you decide to go to the magistrate's court. So let's go through, we'll speed run. We're actually going to go through the investigation now. As we do, I want you to fill out the information that you see. Okay, I'm going to tell the story. I want you to fill out the information you see and tick off the elements that you think you've proved. All right, so we're at stage 3, gathering and managing the evidence. You need to take a systematic approach, follow proper procedures, maintain chain of custody, and most critically, document everything. So we'll quickly cover the difference between evidence versus information. Both are types of information, right? Both are stuff we use to understand something. However, information is just a fact. It's a fact about something or someone. It's an observation. Evidence is information that is related to your offence in question and demonstrates or proves an element. So all evidence is information, but not all information is evidence. You can use information to further your inquiries. So, in CSI, they get a lead. Information is a lead, but it is not necessarily evidence. Now, that's a bit of a tongue twister right now, but I think by the end of this case study, you'll be across it. All information is fake. Oh, no, you're right. There's obviously false information. That's true. Yeah, sorry. So to admit information as evidence, the evidence must be obtained lawfully. It must be relevant to the matter. It must comply with rules of evidence. So we have legislation here that governs this. This is one of the important reasons why you should have policies and templates in your organisation, so that you're not having to think about these other integrated pieces of legislation. There are some other rules of evidence. We're running behind time, so I'm not going to go through all of them, but I will point out the hearsay rule. Essentially what this one means is, as an investigator, you can't use information that is deemed as hearsay, so you heard it from another party. Your neighbour came over and told you that she saw your other neighbour blow up her mailbox the other night. That's hearsay. You don't really know who's done it. You can't verify the information. So under the rules of evidence, you could not admit that information as evidence in a case. Does that one make sense? Cool. Yeah. Sure. So we're going to get into that. Then that's a part of our investigation. That's a witness statement. That is a valid pathway of turning information into evidence. We've already looked at how that works. So you're going out to your site. This is a bit of context for those of you who haven't done an investigation. The officer will get there. They'll have to secure any evidence, document and photograph things, look for identifying material. That's a key step. It's one of the most common ways people find information to further their investigation. You'll be surprised how often officers find bills and receipts with names on them in dumped rubbish. Often they're able to interview someone informally, usually the reporter, and check for witnesses. A lot of the super motivated, engaged officers like Lisa will do door knocks in the vicinity. But before doing all of that, the first thing they do on scene is a safety check. So assess for hazards. Is there anything there that is going to has a risk of harm to the environment or people who pass by? And then that determines a lot of the responses that you have to take as an organisation. Again, you should have a policy. So findings at the scene. You come across a gas bill. You come across a postcard and an invoice. Can everyone see that? Yep. Some key things to think about. You have a a council managed road and you have a council managed reserve on either side of the road. But the dumped rubbish is actually sitting across council reserve and also partially on private land. Does that specific piece of information change the way that we need to go about our investigation? In New South Wales? In some states it does. So this comes back to delegations and authorizations. You need to be aware of your powers of entry whenever material is on private land. So please review your legislation. Not all authorized officers automatically have powers of entry. They require delegations. Those delegations are, a written notice, a written document from usually the CEO of the council outlining that they have the power of entry and the specific part of the act that enables that. If you don't have that and you need it, then you would not be able to go across and grab that gas bill. Okay? It's a very good point. In cases where there's no clear denomination of land ownership, it's a very good point. And it often happens, and you often have people arguing over who has to clean stuff up, etc. So for simplicity, we've presented it this way. The point is that you need to understand that if you're entering private land, you must have powers of entry. Right. Mm-hmm. And if you've obtained it without appropriate powers of entry and a switched on lawyer, it gets to prosecution, and a switched on lawyer notices this, your case is blown. Yes. Yeah. Yeah. Again, first thing we talked about, authorizations and delegations. Yeah, there are mechanisms under most acts to allow that. Request for information, that sort of thing. It is an option, yes. Yeah. Okay. So the other thing you notice, oh no, looks like asbestos. So this should be ringing alarm bells as an investigator. First of all, it would change the way that you go through your policy and procedures. There'll be occupational health and risk requirements. There'll be testing requirements usually. But from the investigation standpoint, let's focus on that. Does it change the offence that you would look at? Why don't you take 30 seconds to have a look at your legislation and see, does this piece of information change the offence that you're now investigating? Okay, let's keep going. So a lot of you rightly identified that the presence of asbestos, it may trigger a different offence. In all of the offences, in all the acts, you have to prove that it's asbestos. It's an element of the offence. So naturally, we need to get testing done. All right, into a bit more detail. So you had a chat with David Boone, who's the reserve manager. He told you that the CCTV's busted. But Beth, the neighbour, told him that she saw the culprit do it. And she said it happened on the morning of the 9th of May. She provided him with a description of the vehicle. And just to recap, you've identified some materials, a postcard, a gas bill, carpet laying invoice, and noting that they're all addressed differently. And then you've got some suspected asbestos containing materials. So next steps as an investigator, we have to follow the leads, we have to follow the information that we've gathered here. So I'm not going to get ahead of myself. Interviews. We saw 3 different materials recovered, all addressed differently. So we probably want to go organise some interviews with these people to understand how the material that they once had in their possession has ended up in your pile of dumped rubbish. We also want to get some testing organised for that asbestos so that we can demonstrate the element. And we want to record the information from David, but does anything about that information jump out at you? Could we use it as evidence? No, because it's hearsay. Yeah. Important information, but we'll go off and interview Beth. Maybe we can get some evidence from that. So interviews, not going to cover it. There's some general guidelines for interviews. Your organisation should have guidance on how they conduct interviews and how you record interviews. Really, really important. The only thing I will add, if it's a suspect, legal requirement to caution them. If it's a witness, it's good for you to understand their willingness to go to court. If they're not willing to go to court, puts them in the realms of an unreliable suspect, right? It's not the information is not as useful for you if you proceed to prosecution. Okay, so you go off to Beth, you get a witness statement. She saw a white Hilux ute with tip tray. She noted down the registration number, the date, the time, even a description of the driver. She must have had a notepad ready, and noted that he drove off really quickly. Would any of this go into your evidence matrix? Fair bit of this information would, right? Yeah. So what are some of the key points you'd be putting down? Registration number, date and time. Great. And with a registration number, is that evidence? If we get a signed statement from her, and then also we can support that with some additional information by conducting a vehicle registration check. Okay, so you've had a pretty successful site visit. You got a lot of information. You've come back, time to review the information, identify gaps. So what are the elements that you are missing? Conduct follow-up inquiries and verify any additional statements. An important part here is cross-referencing information. So we just spoke about that. Beth gave us a registration number. We can look up the information associated with that registration number. We need to cross-reference the information to turn all of this into evidence. We've already touched on this. We can't use David Boone as evidence, it's hearsay. But we can use Beth's witness statement as evidence, especially if we cross-reference it with the additional information from the vehicle registration check. Okay, let me get to my notes. Oh, going to skip over this. We've already spoken about it. That's about powers of entry. So we know how important it is to know whether you have power of entry. You're off and you're doing some resident statements. So you go to the people who are identified on the material you found in the dumped rubbish. You find out that Phoebe Litchfield is 12 years old. While you technically can interview Phoebe Litchfield, there are additional requirements when it comes to interviewing a minor. And as an investigator, you need to balance your need for information for your case with any of the other possible outcomes. So if you think this case gets to a point where you are taking it to the magistrate's court, do you want to be taking Phoebe Litchfield as a 12-year-old through the magistrate's court as a witness for your case? Illegal dumping is terrible, but I don't think it's worth doing that to a 12-year-old. So instead, let's look for an alternative. We know that the information was associated with the carpet removal, so it probably wasn't actually Phoebe who had anything to do with it. So instead, we'll interview her dad, Keith Litchfield, and Megan Schutt and Glenn McGrath. While you're doing all that, you received confirmation that it is in fact asbestos, right? Noting that you have done this through a certified lab. It has NARD accreditations, and your chain of evidence has not been compromised. Again, all of that should be covered in a policy by your organisation. You should not be winging this stuff. You go off and you do a registration check. It tells you that it was a white ute. That's cross-referenced information. That's good. Gives you the name, Benjamin Andrew Stokes, and the garaged address. What are the next steps as an officer? What would you do? Interview Benjamin? Yeah. Is there anything else you can do before you interview Benjamin? The other people? The other 4 people? Yeah, we've already interviewed them in our little story. Spot on. That's right. So we have a name and an address. In our story, we have here that the officer goes out. He or they have a look at the address. They note that the vehicle's actually there. They note that the vehicle has a business name. And that leads them to identify that Benjamin is running a commercial business. Okay. So far we've written down some details. We've got vehicle registration check, owner, address. Oh, that's meant to be a heading, witness statement. Some key details of the witness statement. Really, this is documenting that we have cross-referenced information where we're setting the basis to turn it into evidence. And then there's a picture of Ben the handyman's ute. So we've got a pattern emerging. We've done some resident interviews. We found out that Phoebe's parents hired Ben the handyman. We confirmed that Megan hired Ben for renovation. And Glenn McGrath has an invoice for carpet laying and confirms that Ben removed old carpets. We've got vehicle registration details. And we've matched the vehicle at the observed garaged address. We have also confirmed the presence of the asbestos-containing material. So in our evidence matrix, are we ticking everything off? We're getting there? We're definitely getting there. It's almost like this was put together. So the next step, as Elliot rightly said, we're going to go out and interview Benjamin Stokes to understand how this material that we suspect was in his possession has ended up on our land. We know that the waste was disposed of as ACM. We now know also the volume and the weight because we've had to get someone to remove it and we've had to pay for it. We offer Mr. Stokes a record of interview, which he refused. In each state, you're going to have different processes here. You'll have different tools available to you, and also different terms required as you go through this process. So we are showing you some general ideas, right? Again, think about the principles. So we go to him, we offer a record of interview. We say to him, we want to know what's happened in this scenario. He's refused. So we formally send him a show cause letter, right? Again, he did not respond. And in the meantime, we've done a bit more information gathering and we've noticed that he received a penalty notice in 2024 from a neighbouring local government area for illegal dumping. So we get to a point where we start to document the investigation. We can't go much further because we have a suspected offender who is not really willing to talk to us. And so we need to document appropriately and make a decision. Can't go on forever. So this is very critical. We need to compile all our information and compile what is evidence and prepare for decision making. Your organization processes and templates will definitely come in here. One of the key things that you need to ensure as an officer is procedural fairness. So procedural fairness must occur before a decision is made that adversely affects someone's interests. So we're all sitting here thinking he definitely did it, but we can't say that he's done it because we have not given him effectively a right of reply or a right to defend himself from the actions. So it has three parts: a fair hearing, impartial decision making, and final decision supported by evidence. So because, I'll just unpack those a bit more. So fair hearing is that he has a right to know, or the offender has the right to know the allegations that are put forward and are given an opportunity to respond. The other ones are relatively self-explanatory. In our circumstance, he wouldn't talk to us, so our show notice letter is our procedural fairness, right? We gave him an opportunity to respond. In our case, he did not respond. Come back and look at that in your own time. So we're at a point now where we put a final case together. We've got confirmed facts. We've got a suspect response. He declined an interview, no show cause response, with vehicle confirmed at the address, and we also know that he's still advertising the exact same services that our witness statements have provided. So spend a minute now. We're in the last 10 minutes of the session. Spend a minute or two. Would you, with what's in your evidence matrix, would you go to court? Have a chat. All right, folks, we'll keep it going. Can I get some shout outs? What was your decision? Go to court? A risk of reoffending, so go to court. Also hazardous material, risk of harm to the environment and people. And we have, the previous. If he admits to all the evidence, as a counsel, what would happen is you as an officer would submit it to your prosecution's team and they would make a decision. It ultimately will depend on the cost to council, and whether the cost benefit of proceeding with prosecution makes sense. Sometimes it doesn't, and it's really frustrating as an officer. Yeah. So the point of going through prosecution is that you have higher penalties available to you. And also in most jurisdictions, the courts can order cleanup costs to be reimbursed to the council, which can be a really big deal with things like this. So the final part of this is sort of some guidance on how we make that decision. And a lot of it's common sense. You've already, all of the people in the room pointed it out. We've looked at the risk of reoffending, the risk of harm to the environment or people, the fact that he did it in the past. Another one I'd throw in there is that he didn't comply. He didn't wish to speak to us in any way. And we know that he's continuing to conduct the business. So deciding and documenting. As a group, we've decided he's going to court. So that's fine. Let's say that. But you and your organization might not make the same decision, right? You will have a policy, I hope, that provides you with guidance on how you conduct your compliance. So this is an example of a compliance spectrum. This is one that Jason has made. It's a reinvention of the one from 1980s, which is based on, education, non-compliance, and basically increasing enforcement activities. This one balances the offender's compliance, whether they did it voluntarily or assisted, or also with their non-compliance, was it by accident? Like, for example, did we not have the right address? Did they not get the material or the communication? All the way up to our offender, intentional non-compliance. And then on the other side, we have the cost per outcome. So that's where council or your organisation can start to balance, is it worth taking this person to court? Is it worth pursuing this activity or this decision? For a cigarette butt, probably not. But for a couple of tons of asbestos, probably. There's more details in the actual slides. Look at them when you're ready. I've been banging on about your organisational policy. The reason is because it empowers your officers. So it gives them permission to act. It sets priorities. It outlines the process they will take. And often it will outline the decision-making process they will take at this point of an investigation. And that provides consistency across the organisation. It also protects your organisation and it protects your officers because it provides them boundaries that they can operate within. That kind of comes back to our authorizations and delegations. Not everyone has the same boundaries. There's accountability, and because you've documented everything so well using your evidence matrix, there's protection from complaints. You can explain the way that you've arrived at your decision through this investigation. Often the complaint won't come from the suspect. It'll come from a reporter who's not happy with the outcome. So you need to be able to explain the process you've undertaken and why you've ended up where you are. Key thing is decision records. You will have a template, but it must include the facts that you established, the evidence you relied upon, so making sure we've turned information into evidence appropriately. It'll detail the offence elements you've proven and explicitly detail how you followed procedural fairness. So what actions did you take for that? Then the enforcement option chosen and the reason for that decision. We all just went through that as a group. And sign off from your supervisor, which should be really easy if you followed your template. Some of the options that are available, they're similar but different mechanisms in different states. No further action, usually unlikely. I've not seen that one very often. Informal education or a warning letter, sometimes a caution. Those are often accompanied with the offender cleaning up, or a requirement that the offender cleans up, so the council doesn't have the cost. And then you get to the higher regulatory responses like penalties, enforceable undertakings, and we jumped straight to prosecution because we don't like him. Okay. So key takeaways: authority, know your act, know your authority, know your powers under the act. Plan your investigation. Go through that process of understanding the offence, elementizing the offence, and understanding the defences. We didn't unpack the defences here today because we created a case study for you where there weren't really any defences. In the real world, there will be defences. And as Lisa said, they're clearly outlined in the Act and often are quite easy to overcome. Have a policy, document everything, have contemporaneous notes, records, evidence matrix, and templates. Natural justice is our procedural fairness. Collaborate when you can and decide defensively. Every time you're documenting something, making a decision, make sure you're making it within the governance framework of your organisation, and assume that someone is going to come back and question your actions and your decision making, and that you'll be required to defend it. Okay? So that's a high level overview of, I guess, the approach to investigations. We've used illegal dumping as a case study here. I encourage you to go back and get to know the legislation in your state. Any burning questions? You can come chat to me if you have burning questions this lunchtime. Yeah, cool. Thank you, everyone. See ya.